Aspirants, here I am Pallavi Rai. Today we will discuss a very important chapter of Civil Procedure Code, which is written statement. So let's get started. Uh, as we are aware that Order 8 deals with the written statement, but before jumping to the Order 8, we quickly recall the rule of Order 6, which deals with the pleading. Because Rule 1 says that pleading is not only plaint but also the written statement. So, all the rules of Order 6 doesn't only deal with the plaint but also with written statement. So, whatever the important rule of Order 6 we have already discussed in the plaint video. So go and check there, and now we will move on to the Order 8. So let's get started. So we are aware that Order 8 not only deals with written statement but with set off and counterclaim as well. So but today we will discuss about the written statement. And the very first section of Order 8 deals with a written statement. As we are aware that what the pleading is, pleading means a plaint, and a written statement. And pleading by plaintiff is a plaint, and pleading by defendant is a written statement. So the written statement is a pleading filed by the defendant after service of summons within 30 days. Within 30 days from the date of service of summons, he will have to present his own statement, his pleading for his defense in the court. But if he fails to do so within that 30 days, he will not be allowed. But in some cases where court has recorded recorded reasons in writing, he may allow the defendant to present his written statement within court, but not later than 90 days from the date of service of summons. And this is the rule 1 of Order 8, which is written statement. There is a prescription of time which is of 30 days and 90 days. In first instance, court will allow him to file his written statement within 30 days, but if he fails to do so, court will allow him to file within 90 days from the date of service of summons. So this is the rule 1 of Order 8. Now we will move on to the Order 1A. So the rule 1A of Order 8 deals with the duty of defendant to produce a document upon which his relief is claimed or relied upon. So this rule is identical with the rule 14 of Order 7. There, the duty of plaintiff to produce the document upon which his relief is relied upon, and here the duty of defendant to produce the document upon which his relief claimed or relied upon. So, where the defendant bases his defenses upon a document which is in his possession or power in support of his defense or a claim, he shall produce it in a court and deliver the document and copy thereof to be filed with the written statement. But if that document is not in the possession or power of the defendant, he shall state in whose possession and power it is. And a document which ought to be produced in the court by the defendant and it is not so produced shall not produce or receive in evidence on his behalf at the hearing of the suit without the leave of the court. But this rule doesn't apply. Where it doesn't apply? It doesn't apply to the documents which is produced for the cross examination of plaintiff witness. If you could recall the provision regarding the cross examination of plaintiff witness, you could recall 139 of Indian Evidence Act. There you can get that cross examination of person who is called to produce a document. And it also not apply to the document which is handed over to a witness merely to refresh his memory. This provision is also under the Indian Evidence Act section 159. So these both the provision of this rule doesn't apply on the 139 of Indian Evidence Act as well as 159 of Indian Evidence Act. So this is the rule 1. So that was the rule 1 name. So we will move on to the rule 2. Rule 2 says that new fact must be specifically pleaded. The defendant, in response of his plaint, must raise his pleading all the matter which shows that suit is not maintainable, whether it is void or voidable, it is time barred, or it is because of fraud, the facts showing illegality. These all facts must be specifically pleaded in his plaint by in his pleading by defendant. So now we will move on to the rule 3. Rule 3 talks about the denial of fact. So in rule 3 there is a provision of denial by the defendant of the ground alleged by the plaintiff. So what the defendant should do? Defendant must specifically deal with each allegation made by the plaintiff of which he does not admit the truth, but he could not deal with the damages. He could not deny to the damages. So this is all about the rule 3. Now we will move on to the rule 4, which is evasive denial. What the evasive denial here means? A defendant deny an allegation of fact in the plaint, and he must not do so evasively, but answer the point of substance. What does here means? He has to deny the fact, but by the answer of the substance, by the answer of the allegation. He has not to deny the evasively, because if he evasively deny, he could waive the allegations. So if it is alleged that he received a certain sum of money, it shall not be sufficient to deny that he received the particular amount, but he must deny that he received the sum or any part thereof, or else set out how much he received. Okay, now rule 4 says that if plaintiff has claimed that alleged that he received a certain sum of money, it shall not be sufficient for the defendant to deny that he received that particular amount, but he must deny that he received that sum or any part thereof. How much he received? He has to say how much he received. So he had not to evasively deny, because it could waive the allegation and plaintiff could win that allegation. So the next important rule is rule 8 of order 8. The rule 8 says that any ground of defense which has arisen after the institution of suit or presentation of written statement, whether it is claiming a set-off or a counterclaim, may be raised by the defendant or plaintiff in his written statement. What does here means? If any ground of defense has arisen, he may claim in his written statement after the institution of suit or the presentation of written statement, whether it is for claiming a set-off or a counterclaim. The plaintiff or defendant can raise it at that time. So the next important rule, which is substituted by 2002 Amendment Act, which is Rule 9. Rule 9 deals with subsequent pleading. What does Rule 9 says? Rule 9 says that if you have to raise or you have to add some subsequent pleading, no pleading subsequent to that written statement shall be presented other than by way of defense to set off or a counterclaim, except you can plead subsequently except by the leave of court and upon such term as court thinks fit. but court may at any time require a written statement or additional written statement from any of the parties and affix a time of not more than 30 days for presenting the written statement or a subsequent pleading or an additional written statement. So the rule 9 says that no subsequent pleading is allowed after the to the written statement of defendant. Only it will be allowed by the way of defense to set up or by the counterclaim, but it could be allowed. It could be allowed with the leave of court and upon such term as the court thinks fit. But the court may require within a 30 days court may require within a 30 days for presenting any written statement or additional written statement, and the defendant should present his written statement within that specified 30 days. This is all about rule 9. And the last important rule of order 8 is regarding written statement, rule 10. Rule 10 says that procedure when party fails to present written statement called for by the court, when any party from whom a written statement is required under rule 1 or rule 9, party fails to present the same within the time permitted or fixed by the court, and the court shall pronounce the judgment against him. If he fails to present the written statement within specified time, which is 30 days, the court shall pronounce the judgment against him. What is the consequence of rule 9 or a rule 1? If party fails to present the written statement within that specified time which court has fixed, the court shall pronounce the judgment against him or make such order in relation to that suit as it think fit, and on the pronouncement of such judgment a decree shall be drawn up. So this is all about the written statement. In this video I have not included the part of set off or a counterclaim because I had just talk about the written statement and the important rule regarding the written statement. But whenever defendant has to claim for set off or a counterclaim, it will be dealt in another video, and we will discuss these provision in another video. So this is all about written statement, and this is the important rule of written statement. I have not covered all the rules, but it is important for MPCJ. What the rules, whichever rule is important for MP civil judge, I have just included this. But you have to read all the rules at least once or twice, but focus on these important rule mainly. So it's all for written statement.